Who is a debt collector? The Supreme Court undermines the Fair Debt Collection Practices Act and what you should do about that. Brought to you by YourLegalLegUp.com, your advantage if you're being sued by debt collectors. Bowing down to the interests of money, the Supreme Court seems to be trying to destroy the Fair Debt Collection Practices Act. It seems to be happy to let debt collectors run roughshod over the rights of consumers, and the debt collectors are sure to try to do that more and more. The new rulings are going to make it much harder, I think, to hire a lawyer to defend against or sue a debt collector. But since most of your defenses are unchanged, that really just means that you're more likely to need to defend yourself pro se than you were, and you can do this. I'm talking about the Supreme Court's ruling in Henson et al. Versus Santander Consumer USA, Inc., that is, Santander. The full citation is in the notes. The Santander decision will make it harder for you to get a lawyer and cause debt collectors to engage in more deceptive, dishonest, and abusive behavior because it narrows the definition of debt collector under the FDCPA so much that it hardly includes any real debt collectors at all. In effect, the Supreme Court has declared open season on consumers. Let's take a step back and look at the FDCPA. When Congress passed the FDCPA, the corruption and destructiveness of the debt collectors were so rampant, debt collection was considered a threat to the American way of life. The FDCPA was designed to prevent fraud, deception, and unfairness in general in the collection of debts. Congress realized that businesses will shift and change to avoid the impact of law, so Congress named several specific actions as per se violations, that is, by themselves, without any other proof, but also included the more general description of unfair and unconscionable debt collection practices. The reason for identifying numerous specific practices, as well as including the more general rules, was explicitly to keep debt collectors from avoiding the law by changing the forms their actions took, without changing what they were essentially doing. Congress did basically the same thing with the coverage of the Act. They only wanted to cover debt collectors and not original creditors, as I've explained often before, so they exempted original creditors from coverage and said the Act only applied to debt collectors. So then they had to define what debt collectors are, and here's how they did it. The term debt collector under the Act means any person who uses any instrumentality of interstate commerce or the mails in any business, the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect debts owed or due, or asserted to be owed or due to another person. In the now good old days, most courts recognized that when a company bought debts from the original creditor long after they were in default, or from some other debt collector, the debt collector was buying debts asserted to be due another. The fact that the debt collector purchased those debts didn't change the fact that the debt was allegedly due another person, because the ownership was at that point viewed as a matter of form rather than substance. In its Santander decision, the Supreme Court cheerfully elevates form over substance to allow the same actors to do the same terrible things that the FDCPA was designed to prevent. In looking at Section 1692A(6), the court examined the defining language of debt collector in the FDCPA as any person who regularly collects debts alleged or asserted to be due another. They ignored, in other words, half of the definition because the plaintiff had not alleged that Santander's principal business was debt collection. The court's decision then repeatedly referred to and emphasized the words due another, arguing that companies were only debt collectors if they fit that traditional form of collectors. And they ignored the statute's obvious intention to cover all kinds of debt collectors by using such a broad definition. Thus, they excluded debt buyers from that part of the definition of debt collectors. Debt buyers now become creditors when they buy the debt. The court ignored the other half of the definition of debt collector, the fact that the statute was intended to be broadly read, and the definition was intended to be inclusive of all people collecting debts generated by other people, and also the fact that Congress had exempted original creditors explicitly from the definition. They ignored all of that. and held that when you buy the debt, you become the actual creditor. So now there's no distinction between junk debt buyers and original creditors in the Supreme Court's version of the law. Let's consider the reality of debt collection for a second. What happens in most debt collection these days is that creditors sell charged-off debt to debt buyers, most of whom exist entirely to collect that money by hook or by crook. Not all of them. As a matter of fact, Santander didn't, because it was a bank that also happened to lend some money. But you know good and well that the part of Santander that bought the debt acted as a pure debt collector, right? Instead of hiring debt collectors to collect on debts and then paying them out of the proceeds, as they used to do, creditors now get their money first and let the debt collectors take their money from the debtors. All that has happened is that nominal ownership of the debt has changed, and not necessarily as much as you might think. That's because the transactions are designed to limit the amount of risk that the company buying the debt takes. In theory, the decision in Santander leaves open the possibility that the alternative definition, that is the principal purpose definition, would extend the meaning of debt collector to junk debt buyers. On the other hand, the decision looks to me like a court in search of a justification for its desired outcome, and it has to be viewed as a negative indication for the court's integrity and also for your rights as a person with debt collectors after you. Particularly in the context of its decision in the other case that I talk about in my companion video, Midland Funding versus Johnson, and see my article and video opening the floodgates of bad claims. It shows actual hostility to the laws that protect consumers and a willingness to engage in games to destroy them. As a practical matter, it will likely be several years before the Supreme Court revisits the definition of debt collector and applies the entire definition to the question of junk debt buyers. It may not do that for decades. Meanwhile, the lower courts and lawyers will try to figure out what it means. Here's what it means for you, the person facing debt collectors and harassment. Before now, debt defendants have normally found it very easy to prove that a company regularly collected debts. In fact, under prevailing Eighth Circuit law, for example, if a law firm represents debt collectors in as few as 3 to 5 cases per year, it's considered to be regularly collecting debts. Been a lot of talk about that. That's easy, and the facts that prove whether someone is a regular collector of debts are a matter of public record. Establishing a business's principal purpose will be much more difficult. The term principal purpose is frequently used in judicial decisions, but its use is primarily generic, as a synonym for main or major. I haven't seen a case that attempts to quantify exactly what makes something the principal purpose of a business. But whatever the facts may be, they'll be in the private control of the debt collector, and that means you'll have to fight to get them through discovery. If you're currently involved in a case with a claim under the FDCPA, expect the other side to bring a motion to dismiss. They'll claim they aren't debt collectors, and you'll need to amend your pleadings, if you can, to include the principal purpose language of the statute. You'll need to do the discovery to back that up, too. If you're trying to get a lawyer, expect it to be much more difficult to do. Most lawyers are going to be scared by Santander, and even if not, it will mean more work for them and less likelihood of getting paid by the debt collector in the end. That means they'll look to you for the money, or they simply won't take the case. But what you have to remember is that the recent cases did not affect your defenses, at least not much at all. You can still fight it, and you still should fight it. But you're probably going to have to do it pro se. You can use our services to help you. Protect what's yours and don't let the debt collectors rip you off. YourLegalLegUp.com